A Nova Scotia woman is looking for answers after her sexual assault case was derailed because of a police misstep. The case was thrown out by a judge due to delays after the RCMP lost her rape kit. Lindsay Jones has more.
This woman says she did everything by the book after she was sexually assaulted in April of 2017. We're calling her Nicole because her identity is protected by a publication ban.
I had believed that the accused confessed. I believed that the Justice Department had everything that they need to proceed with this, and it still failed.
Nicole first met Jordan Ellis on a popular Facebook group. Weeks later, she drove to meet him at this gas station near his home in Hillsburn. They spent the day together, driving around in his red Honda Civic and hiking in the woods. Before she made the 2-hour drive back to her home in Lance, they agreed to go for one last drive to smoke cannabis. They parked on a remote road in Annapolis County. Nicole testified in court that she told Ellis no when he made advances. She said he grabbed her and had non-consensual sex with her.
I had a forensic rape kit completed by the SANE team at the Cobequid Emergency Room. I had gone and I provided the GPS locations, information on the accused.
After the incident, Nicole and Ellis exchanged text messages, which were later admitted in court. He says he got too worked up and apologized. At the hospital, nurses took photos of Nicole's injuries. She says she suffered when Ellis had her back pressed up against the emergency brake. She says he also bit her on the right breast. But the police lost the rape kit form and a CD of the photos, which had been in the care of the Bridgetown RCMP. At trial, Ellis pleaded not guilty and did not take the stand. His lawyer, Zeb Brown, argued the encounter was consensual. The lost rape kit eventually turned up, but too much time had passed, and Judge Alan Tufts wound up staying the sexual assault charge. In his decision, he cited the lost evidence and the double booking of a courtroom, which led to unreasonable delays. These violated Ellis's charter rights. The RCMP won't talk about the lost evidence because the matter is in the process of an appeal.
The RCMP has general policies and procedures in regards to the collection, handling, and processing of exhibits. So this includes detailed processes for marking, storage, and preservation of evidence. Supervisors and managers are responsible for ensuring that our members follow these processes and protocols.
The Crown, who prosecuted the case, says he didn't know a rape kit existed until Nicole brought it up on the stand.
Yeah, any kind of evidence, any kind of mix-up in disclosure, things that should be provided that aren't, is problematic. Yeah.
This women's advocate says it's absolutely unacceptable that sexual assault charges would be thrown out because of mistakes in disclosing evidence.
Very few victims of sexualized violence come forward, and they come forward reluctantly, often because of fear of what could happen in the legal system. So when there are mistakes or delays in terms of the sharing of evidence in the way that would be expected, that leaves complainants in general and society feeling a level of distrust potentially in terms of the system, and that's disappointing.
Meanwhile, Nicole feels let down and re-victimized by the system.
I would like to see Jordan Ellis go to court and have a decision made against him on the merits of the case. I'd like to see the RCMP members involved in my particular case disciplined if necessary. I would like to see an explanation as to why my evidence was misplaced for so long, why it wasn't labeled, why transfer of evidence procedures were not followed.
Nicole lives in fear. She now owns a guard dog and grocery shops in the middle of the night. This is the only way she knows how to be as she waits for the Crown's appeal to unfold. For CBC, I'm Lindsay Jones.
It's not only in Nova Scotia where the RCMP are facing criticism. They are facing backlash in Kelowna as well. Sexual assault survivors rallied outside the Kelowna RCMP detachment over the weekend. They were angry over data from Statistics Canada showing Kelowna RCMP classified 40% of 2018 sexual assault cases as unfounded. This is 3 times the provincial average. Joining me now from Kingston, Ontario to answer your questions on RCMP's sexual assault case standards is Blair Crew. Blair is the Director of Legal Aid at Queen's University. He is an expert on the unfounded issue here in Canada. Blair, welcome to you.
Thank you.
We are going to talk about both these stories tonight, but first, tell us about your work around the issue of unfounded. And before we do anything else, I'm going to get you to explain what it means when a police officer concludes a case is unfounded.
Thanks, Carol. The definition of unfounding is when, after an investigation, the police have determined that no crime occurred. It's tantamount to a finding that the woman or the survivor has misled the police or fabricated the allegation.
Okay, so when you hear...
With respect to...
Oh, sorry, but when you hear 40% in 2018 of all cases investigated by the RCMP in Kelowna are unfounded, how does that strike you?
That's about the highest rate that I've ever heard from any police jurisdiction anywhere in Canada. My work with this began approximately 20 years ago when I did civil litigation, and a number of people, usually young women, would come to me complaining that they'd gone to the police and had advised of a rape, and that the police, for whatever reason, told them that they were lying and that they would not be going ahead with the charges. Often the women were looking to sue the police, and I still to this day haven't found a way to do that, but it has led to a sort of a sideline career for me of advising women on how to navigate their way through the police system.
Right, and you worked with Robin Doolittle and made national headlines.
When I heard that this was happening so often, it was in Ottawa, and at the time, about 30% of all the complaints in Ottawa were deemed to be unfounded. I, as a white male, was so surprised to see the number of women that would come to me telling the same story. So I began with some other colleagues a short study where we did freedom of information requests for some Ontario jurisdictions and found that Ottawa was the highest, but that a rate in excess of 25% of cases being deemed to be unfounded was fairly common from across Ontario. Only Toronto was better at the time, having been through the Jane Doe case at that time. So, but to hear a number like 40% is quite exceptional to me, and particularly after Robin Doolittle's study, I'm surprised that it is still so high. Robin notes that when she began researching this issue, she found one of the articles that I wrote as a result of that small study, and that became the inspiration for her to use the natural resources to do the freedom of information request for every police jurisdiction in Canada.
I believe the RCMP has put Kelowna under the Kelowna detachment under review, but what is your reaction to this story in the Annapolis Valley in Nova Scotia, where the RCMP lost a woman's rape kit and then couldn't find the photos for the longest time, and then found them, unattached to any file at a detachment 25 minutes away?
It's really quite a shocking development. Every survivor that comes forward has a measure of resiliency and hopes to see justice done in court, but I agree that Nicole did everything correct in this. I think there was more than enough evidence that he could have been convicted. Despite that, the defense is entitled to have every piece of evidence that is out there. So when she testified as to a rape kit that was not yet to the hands of the defense, then of course the defense became entitled to that, and it resulted in a long delay. But it is shocking to hear, particularly where there has been criticism of police force for their handling of sexual assault investigations, that something like the rape kit could just be lost in this day and age. That suggests to me that there were procedures or protocols that either didn't exist or, more likely, were simply not followed.
Yeah, I find it hard to believe that the RCMP, a national police force, would not have procedures and protocols around evidence, the preservation of evidence.
I know for a fact that they do have such protocols. They apply to sexual assault cases in particular, but to all kinds of cases. A murder, of course, is going to be important as well, and they're going to want to preserve the evidence in a case like that. So it was astounding to hear the kind of callous way the evidence was treated in this case. Now, I do suspect that the jurisdiction from where this happened, I know it's a small town of about 1,000 people or so. I understand that the police detachment is only 16 people. people. That suggests to me that it's small enough that likely the investigator, they certainly would not have a sexual assault squad. The investigators would be more generalist without the specialized training that the courts have repeatedly recognized is needed for sexual assault investigations.
Yeah, and sexual assault is such a common crime in this country, sadly. You would think every police officer would be trained on how to deal with it.
There's still an awful lot of myths that surround the investigation and prosecution of sexual assault, and the cry to have specialized detectives in every detachment is something that has been repeated over the years. At the same time, there are smaller jurisdictions where that doesn't occur. Also, the unfounding movement is a relatively new thing that coincided with the timing of Me Too. And the police forces are increasingly recognized their need to have further training. Okay. Still, to hear that they could have mumbled this one so badly is quite surprising.
A lot of Canadians curious about how it happened. Our first question comes from Liam. He tweeted, was it more systemic laziness of the sort Robin Doolittle exposed years ago?
Certainly, whenever something like this happens, one has to ask what's behind it. One has to say, how could it be that in this case they lost the evidence? Part of what Robin Doolittle's study suggested was that the police were sometimes not as vigorous with some of these investigations. So the systemic laziness, what's behind that? I can't speak to that, but it does seem to be one of the phenomena that Robin identified.
Our next question comes from Megan. Have a listen.
How does this kind of thing happen, and how do you expect people who still go through things like victim blaming and being asked what they're wearing at the time of these situations, how do you expect them to actually feel safe coming forward when, even when they do come forward and they do everything right, you lose the one thing that could provide them a testimony against this person?
Blair?
Megan, overwhelmingly, the reason why survivors come forward is not necessarily for retribution or anything like that, but rather because it's the right thing to do. And the number one thing that I've heard from those resilient survivors over the year is they came forward simply because they want to protect other women out there. They want no one else to have to go through that. Notwithstanding that, we know Statistics Canada has recently reported that only about 1 in 20 sexual assaults even gets to the police in the first place. And in my role as an advisor to women, after talking with me about what the process is like, several have chosen not to go forward with charges. So it would be hard for me to send someone off to the system expecting justice to be done without the survivor being forewarned that it may not end in the way that he or she hopes. And certainly, it has been the case that I've seen many resilient survivors that have nonetheless found it worthwhile to go through the process. Many others, though, are happy that they never engaged the legal system, where the outcome is often so uncertain.
Our final viewer question comes from Darren. He tweeted, I wonder if it was a mistake, implying that somebody did it on purpose.
We don't know the reasons that have gone historically into unfounding. There is a unbalance in the liabilities. High-profile cases have found that the police can be liable to an offender or an alleged offender if ultimately he is acquitted through what is known as the tort of negligent investigation. On the flip side, I myself have taken a couple of cases to the Ontario Court of Appeal where it's found that the survivor has no interest in the outcome of an investigation. And as long as there is a competing balance of liabilities like that, there's a powerful economic incentive for the police to err on the side of caution from the point of view of an offender and not lay charges. As long as that unbalance exists, we're always going to end up wondering if it was a mistake.
All right. Blair, thank you so much for joining us tonight. Blair Crew is the Director of the Legal Aid at Director of Legal Aid at Queen's University. He's an expert on the unfounded issue here in Canada. And Blair joined us from Kingston. Blair, thank you so much.
Thanks for reaching out, Carol.